Ever stop to think about who's really responsible when an organization lets someone else act for them?
Hmm.
Imagine this. There's a trade dispute, right? Some officers are involved and their association, the State Police Association or EPA, gets involved.
Yeah.
Now, what if the EPA supposedly gave two individuals, Harrison Thompson and Robert Ramatar, what's being called exclusive written authorization to handle it all?
Exclusive authorization. That sounds quite specific.
Exactly. And that piece of paper, assuming it exists, could have some pretty big legal consequences.
Yeah.
Especially for the EPA itself.
Right. That's really the heart of what we're digging into here.
Mhm.
This whole situation seems to pivot on that alleged authorization.
Uh-huh.
Based on the legal analyses and briefings we've looked at, the argument is that the EPA basically handed over control for managing this particular trade dispute to Thompson and Ramatar.
And if that's actually what happened.
Well, the implications under something called agency law, they're quite significant, legally speaking.
Okay, so for this deep dive, we need to unpack this. Using our sources, let's figure out what is this alleged agency relationship? What duties came with it? And importantly, what are the potential constitutional issues for the EPA and the officers involved?
Exactly. We're looking for those moments that clarify who really bears the responsibility here.
We need those aha moments.
Precisely. And the foundation, the absolute bedrock of this, is that core claim. Did the EPA actually give exclusive written authorization or exclusive rights to Thompson and Ramatar for this dispute?
That word exclusive feels key.
It is. It implies a real delegation of authority, not just, asking for some help.
And there's more. Apparently, Harrison Thompson himself said in a meeting, he mentioned receiving a letter from the EPA, a letter giving him and Ramatar these exclusive rights to proceed.
Okay, so that's a direct claim from one of the individuals.
Right.
That statement certainly puts a spotlight on this alleged authorization, makes it seem potentially quite real.
Definitely feels like a key piece of information.
It does. Because, look, if that written authorization is genuine, if it actually exists and says what they claim it says, the whole legal picture changes.
How so?
Under agency law principles, Thompson and Ramatar wouldn't just be acting on their own anymore. They would become official agents of the EPA, but specifically for this task, for this trade dispute.
Which means everything they did, as long as it was within what that authorization allowed.
Yes, exactly. One of our sources puts it very bluntly. Everything they did legally binds the EPA.
Wow.
Think of it this way. It's like the EPA's signature is effectively on every action Thompson and Ramatar took related to this dispute, provided it was within the scope of that authority. It carries that much weight.
So if Thompson and Ramatar were agents, and maybe they made mistakes or misrepresented something,
Then the EPA is the one legally responsible. So that's straightforward in principle.
Yeah.
Our sources are quite clear on this point. The EPA would be held fully accountable for any, let's say, wrongdoing, misrepresentation, maybe even negligence committed by Thompson and Ramatar while they were managing this dispute.
it all tracks back to that initial alleged authorization.
It really does. That's the linchpin.
This letter, then, the one Thompson mentions, it sounds absolutely critical. Is it the smoking gun, potentially?
It's certainly positioned as the critical piece of evidence because it would be the formal written proof.
Right.
If it exists and is clear, this letter isn't just, a suggestion. It's the document that formally establishes the agency relationship and, crucially, it would define the limits, the scope of Thompson and Ramatar's power as agents.
Okay, but what if? What if there is no letter? Or maybe there is one, but it's, really vague. It doesn't explicitly grant exclusive rights.
Well, that immediately raises questions. Red flags, you could say.
Mm-hmm.
The sources suggest that if no such letter can be produced, or if its wording is ambiguous about granting these specific rights, well, legally, that could be interpreted negatively. It might suggest concealment or even misrepresentation of the situation.
So Thompson saying there was a letter is one thing.
Right, a verbal claim.
But having the actual document in hand, that's what holds the real legal power.
Precisely. It's the difference between someone saying, I have permission, and actually showing you the signed permission slip. The paper trail matters enormously in law.
Got it. And assuming for a moment that this agency relationship was established, maybe by this letter, you mentioned responsibilities. It's not just about following orders.
Not at all. Once you potentially establish that agency link, a whole different set of duties kicks in. These aren't just duties to the EPA, but as alleged agents, Thompson and Ramatar would arguably owe specific duties of trust. They're called fiduciary duties directly to the affected officers.
Fiduciary duties. Okay, that sounds important. What does that actually mean in practice here?
Think of it like a heightened duty of care and loyalty. It's a commitment to act solely in the best interests of the people you're representing, in this case, the officers.
So what kind of things would that involve?
Well, our sources point to several key ones. First, a duty to represent truthfully. That means getting the facts right, the correct number of officers involved, the actual nature of the dispute, no fudging the details.
Okay, makes sense. Stick to the facts. What else?
Second, there's a duty to keep the clients informed. Here, the clients are the officers. So Thompson and Ramutar would have had an obligation to give them truthful updates about what was going on, no misleading them or keeping them in the dark.
Right, transparency.
Yes. And third, a duty of candor. This applied especially towards the official bodies involved, like the tribunal and the ministry. They couldn't mislead them either. Full honesty was required.
Okay, so these are serious obligations. What happens if they didn't meet them? If they breached these fiduciary duties?
And this is where it gets potentially very serious, constitutionally speaking. Our sources clearly state that if Thompson and Ramutar fail to uphold these duties, it could lead to constitutional liability. And not just for them personally.
But for the EPA as well, because they were the principal, the ones who allegedly gave the authority.
Exactly. The alleged failures of the agents could loop back to the principal, potentially triggering constitutional claims.
So we're talking about potential breaches of trust leading to claims about fundamental rights violations. Do our sources give specifics on what Thompson and Ramutar are actually accused of doing wrong?
Yes, there are several specific allegations outlined. Things like misreporting the number of officers actually affected by the trade dispute.
Okay.
Also, misclassifying the type of dispute it was. Failing to ensure proper conciliation processes were followed, making sure everyone was properly involved. And even proceeding with certain actions without having the required lawful written reasons from the tribunal.
These don't sound like minor slip-ups.
According to the arguments presented in our sources, no. They're framed as significant breaches. Breaches of both that fiduciary duty owed to the officers and fundamental principles of procedural fairness, which are often protected constitutionally. Due process, essentially.
Now, you mentioned the Constitution, and our sources keep referencing a specific case. N. Del Thomas sounds like it's a big deal in this argument. What's the relevance of that case?
Right, the N. Del Thomas v. Attorney General of Trinidad and Tobago case. It's important not because the facts were the same, it wasn't about the EPA or this kind of dispute, but because it established a key legal principle.
Okay, what principle?
Essentially, it confirmed that when public or administrative bodies act unlawfully, even through their authorized agents or officials, it can engage constitutional protections for individuals affected by those actions.
So if someone acting with official authority messes up badly enough,
it can become a constitutional issue for the body that gave them that authority. The N. Del Thomas case set a precedent for that connection between administrative action and constitutional rights, specifically things like the right to procedural fairness or due process.
Okay, I think I see the connection. How is the petitioner using that precedent here against the EPA?
They're essentially saying, look at N. Del Thomas. That case shows that when an authorized body acts unlawfully through its agents, there can be constitutional consequences.
Uh-huh.
So the argument goes, because the EPA allegedly authorized Thompson and Ramutar, their alleged unlawful actions, the breaches of duty, the procedural missteps should be seen as the EPA acting unlawfully. And that, they argue, triggers constitutional liability for the EPA under specific sections of the Constitution related to fundamental rights and due process. Sections 4B and 52E are mentioned.
So boiling it down, the petitioner is arguing the EPA gave the power, Thompson and Ramutar allegedly misused it or failed in their duties, and therefore the whole process was flawed constitutionally, making the EPA liable based on the N. Del Thomas principle.
That's the core argument, yes. The alleged authorization, combined with the alleged failures of the agents, is claimed to invalidate the entire management of the dispute from a procedural and constitutional standpoint.
And what's the end goal for the petitioner? What are they trying to achieve?
They're seeking constitutional reliefs. Essentially, they want the court to recognize that constitutional harm occurred because of these alleged failures and to provide a legal remedy for the injuries they claim to have suffered.
All right, let's wrap our heads around the bottom line here. When it comes to accountability, what's the main takeaway from all this?
I think the key findings, based on the legal arguments presented, are pretty clear. If that exclusive written authorization was indeed granted by the EPA, then first, Thompson and Ramutar effectively became the official legal representatives acting through the EPA for this matter. Second, their actions within that authority legally bind the EPA.
Hmm.
And third, any wrongdoing, any negligence or misrepresentation on their part is legally attributable back to the EPA.
So the responsibility flows upwards.
Directly. The sources use some strong language.
Yeah. Like what?
One summary states it quite forcefully. They acted with authority, and the EPA owns the consequences.
Owns the consequences. That's clear.
It really underscores the idea that the EPA can't simply distance itself or disclaim responsibility if Thompson and Ramutar were, in fact, acting with their blessing, with their authorization. You can't just say they went rogue if you gave them the power to act in the first place.
So for you listening, the big insight here really is about the weight of responsibility. When an organization, any organization, gives someone else the authority to act on its behalf, it's not just a casual arrangement.
Not at all.
It carries serious legal weight. And as we see here, potentially constitutional weight. If the authority is misused or if things aren't handled properly, the consequences can be far-reaching, landing right back at the organization's doorstep.
It's like you let someone borrow your car, right? If they cause an accident while driving it with your permission, you, as the owner, often still have some liability. Agency law works a bit like that, but often with even bigger stakes.
That's a good analogy. And the aha moment, maybe, is seeing how this legal concept agency connects directly to these really fundamental ideas about accountability, fairness, and due process.
Exactly. Who you empower to act for you says something about you. Their actions become, in a legal sense, your actions. And that can engage basic rights.
Which leaves you with a question to ponder, doesn't it? What does this situation really tell us about the critical importance of clear rules? Clear authorization, proper oversight, and ensuring ethical conduct for anyone acting on behalf of a group.
Definitely food for thought.
It pushes you to think beyond this single dispute about how power is delegated and responsibility is managed in any organization.
Absolutely. And hopefully this deep dive gives you a solid framework for understanding the complexities here. It certainly raises further questions about agency law, constitutional rights, and how these principles play out in the real world.